stating, please be seated quite often. And I'm going to make use of that experience just now to invite all of you, please, to be seated and let us begin this panel. I'm Joan Donahue, and I'm going to just make some brief remarks of introduction before turning things over to our panelists. Let me just first thank all of you for being here for this session today, and to acknowledge the presence in the room of all 5 of the editors of this book, who include Charles Brower, Kian Murphy, Simi Payne, and Esme Sherlow. And I'd also like to thank those contributors who've contributed, and many of whom are also here today. The theme of connections is one that runs through the book, through the chapters, and the way the chapters relate to each other. So some of the chapters make connections between substantive law and procedures in relation to a particular institution. Some of the chapters make a connection between the goals and the mandate of an institution and the actual outcomes, for example. And David's own work often engaged with connections. So I wanted to just mention briefly a few connections related to David that occurred to me as I was thinking about today's session. And my first comment is that David was a true generalist. And as a result of being a generalist, he was able to make connections, see connections, and ask questions about particular subfields of international law that others might not have been able to ask. It's a favorite point of mine because I'm often asked by law students about what should they study, et cetera, and I'm often the one who says to them, don't over-specialize, because you might exclude from the range of ideas that would stimulate a solution to a problem something that really would be valuable to you. My next comment on connections and David shifts to the more personal side and David's connections. At the Hudson Medal lunch today, there was a little bit of discussion of some of the efforts on the part of the society to educate the American public about the role of international law. During David's presidency of the society, which coincided with my early years on the International Court of Justice, I took on a fairly active role in outreach in the United States in places you don't normally think of as hotbeds of international law. And I was always partnering with an ASIL member who was on a law faculty. So, for example, I had very interesting experiences in Idaho. I went to Georgia. I went to Sacramento, California, which is, okay, California's a blue state, but there are areas that aren't so blue, among others. And I was trying to share what international law does and how it's relevant to their lives, often meeting with students and community leaders who were skeptical of international law. And that was something that was important to David, that to reach out to those who weren't true believers. The other personal aspect that I wanted to mention here is one that was really brought home to me shortly after David passed away. There were quite a number of events over a period of months. I recall, for example, an event in the Peace Palace, an event in London, and events in Berkeley. And there was also an informal discussion among various people who knew David at the American Society annual meeting that took place a few weeks after David passed away. And the thing that struck me at those events is I would meet somebody, sometimes I knew the person, sometimes I didn't, and the person would say to me, David was my mentor, and he mentored me on this topic or on that topic. He really helped me on this or that. And I started to notice that each of these people was convinced that David was his or her mentor. They often didn't know each other, and they were working in very disparate fields. So back to the point that David was a generalist. But the way that David listened to people, the way that he thought about what was being said to him, influenced his writing and influenced us in our work in this book to try to develop pieces that listened to different ideas and presented them in an integrated way. It was a side of David that I think was enormously important, and I was touched by the number of people who said these things to me about the way that he had been a mentor to them. I try to remember the importance that they attach to that and hold it close. So each of the authors and editors on today's panel had one connection or another to David. And I'm going to turn this over to the panel now, just first by just introducing them. And so Esme Sherlow, who will moderate, is Associate Professor at the Australian National University's College of Law. And to her left is Philippa Webb, who is Professor of Public International Law at King's College London and is a barrister at 20 Essex Chambers. Next to her is Meg Kinnear, Vice President of the World Bank Group and Secretary General of ICSID. And then on the far left, we have Hannah Gary, who is Professor from Practice at UCLA Law and Executive Director of the Promise Institute for Human Rights, USA. So I thank all of them for this panel, and I turn things over to Professor Sherlow.
Well, thank you, Joan, and thanks to everyone for being here to celebrate the launch of this book and also to reflect on David's legacy more broadly. As Joan has noted, the authors joining today's panel represent really a small cross-section of the book. We had over 30 authors contribute to 28 chapters in the book, and in some, they provide a very rich commentary on various important aspects of the settlement of international disputes by peaceful means. And for those of you who are yet to see a copy of the book, to orient you, we have structured the book into 5 substantive sections, and those examine the history of international dispute settlement, key institutions and institutional actors, cross-cutting procedural questions, issues of substantive law and legal principles, and lessons for the future. And it's really wonderful and gratifying to see so many of the authors of those various chapters, both here but also in the audience today. So I want to start our panel section of the session by giving our panelists a chance to introduce their specific contributions to the book. And I might start with you, Hannah. You authored a chapter in part 1 of the book titled The Eritrea-Ethiopia Claims Commission at the Intersection of International Dispute Resolution and Transitional Justice for Atrocity Crimes. What does the experience of the Eritrea-Ethiopia Claims Commission teach us about the connections between transitional justice and international dispute settlement?
Well, thank you so much for that question, Esme, and also just want to say a huge congratulations to all the editors for this wonderful tribute in David's memory. It was such an honor to be part of it and to be invited, so thank you so much. It's wonderful to be here with you today. And I also just want to thank Meg and Philippa, and it's great to join you on this panel. So in answering the question, I want to just first note that the chapter is really limited in scope to the connections between transitional justice with a very particular form of international dispute settlement, and that is ad hoc arbitral mixed claims commissions. And I'll call them MCCs for short. And I focus in particular on the Eritrea-Ethiopia Claims Commission because I had the good fortune, thanks to a connection that David made with Lucy Reed, my former partner at Freshfields, who was commissioner, who invited me to assist her in her work on the commission. And I learned a ton through the process. And obviously that experience led me to write this chapter, but also because I got to see David as counsel before the commission. So I got to see some of my giants or my mentors, both in the same room at the Peace Palace through this process. So as some of you may know, the EECC was established with the signing of the Algiers Agreement between the two countries as part of their transition to peace after a bitter international armed conflict over the border from 1998 to 2000. And while it was modeled after historic mixed commissions focused on interstate claims for resolution under international law, at the same time as a mixed claims commission, it had jurisdiction over compensation claims brought by tens of thousands of individuals, namely civilians and prisoners of war, who suffered grave harm as a result of violations of international humanitarian law, which we call war crimes. And rather As an international criminal law professor and practitioner for over 20 years now, interested in pursuit of holistic justice for international crimes and atrocity crimes, the EECC's role in addressing war crimes in particular piqued my interest and gave rise to this chapter. International criminal law, we emphasize the importance of individual responsibility as being a necessary and primary tool in the toolkit for achieving transitional justice. And rarely do we think of mechanisms like mixed claims commissions as such. But I found this very puzzling because particularly since World War II, with the development of human rights law, MCCs have increasingly centered individuals on the international plane with a focus on victims and their compensation claims for harm. And they focus on that rather than on perpetrators and criminal accountability, as is done in the international criminal trials. So the chapter really explores whether the EECC and mixed claims commissions generally should be classified now on a regular basis as transitional justice mechanisms. And second, whether the experience of the EECC is instructive for future commissions and some that are being put into use as we speak. To serve as an important complement to criminal trials, which are incapable of effectively compensating victims at scale. So on the first question in the chapter, I conclude yes, where MCCs such as the EECC address reparations for grave human rights abuse, they clearly should be included within the transitional justice toolkit. This is because of the expansive definition for transitional justice outlined in the UN Secretary General's 2010 guidance note, which includes, quote, the full range of processes and mechanisms associated with the society's attempts to come to terms with the legacy of large-scale human rights abuse in order to achieve goals of accountability, reconciliation, truth, reparation, or non-recurrence. So where one or more of these goals are explicit or implicit in the legal basis, structure, and processes of MCCs and outweigh any features to the contrary, then MCCs may qualify as transitional justice mechanisms. On the second question, I find that the ECC experience is an imperfect one from a transitional justice perspective, although an important model to consider, both with regards to its design and execution for future transitional justice contexts. And where MCCs are established with clearly articulated transitional justice goals in their founding documents, as was done in the Algiers Accords with its emphasis on achieving reconciliation and peace, they have potential to serve as an important complement to other processes for addressing atrocity crimes. There is arguably some, even if patchwork, establishment of the historical record and truth-telling, and of course, international rule of law is upheld in the process. The EECC experiment also demonstrates that MCCs may, with their focus on assigning state responsibility, be an important tool for further closing the impunity gap for atrocity situations by acknowledging the role of entities in addition to individual perpetrators. In addition, MCCs provide a more restorative justice approach to atrocity contexts with the reward of compensation or other forms of reparation to potentially large numbers of victims through procedures such as mass claims processes. Similarly, the EECC emphasized remedying abuse of socioeconomic rights, harm to the environment, and promotion of peace and development for affected communities as equally important to addressing violations of civil and political rights that result in grave physical injury to victims, and so demonstrating that MCCs may be a process for a more holistic justice approach. Finally, in light of the considerable flexibility available for their establishment, MCCs can be designed as bespoke transitional justice mechanisms tailored to address specific atrocity contexts rooted in a shared history. On the other hand, the experience of the EECC teaches us lessons for what is required to ensure that MCCs are actually effective in their transitional justice role. In sum, centering individual victims in the process is paramount and requires underlying political will and resources for actual provision of reparations at the end of the process. This can be achieved in a number of ways. First, creation of the MCCs should avoid being a state-driven top-down process. Rather, means should be found for inclusion of a bottom-up approach to both design and execution that in fact affects what we call transformative justice, wherein commissions are both informed by and led by marginalized victim communities to better understand and address their needs. Second, individual victim claimants should have greater access to the process as much as possible. This may be better realized where the seat of the commission is located within or close to the affected communities rather than in The Hague, where individuals are able to bring claims more directly, not only through espousal, where payment of damages is directly paid to individual claimants under enforceable procedures and deadlines, and expenses for the operation of the Commission do not exacerbate the inability of a war-torn country to eventually make payment on claims. In this regard, outside states and international organizations may have a role to play in provision not only of expertise and oversight for purposes of legitimacy, but also resources for actual payment of reparations. Otherwise, from the perspective of victim communities, the process is at risk of being perceived as merely symbolic justice, or worse, no justice at all.
Thank you, Hannah. And I guess reflecting again the breadth of David's interests, turning from MCCs to investment disputes. Meg, you co-authored a chapter titled The Past and Future of ICSID Additional Facility Dispute Settlement, which appears in part 2 of the book, focused on institutions and institutional actors. And so my question for you is, what does ICSID's experience with the recent rules amendment process reveal about the role for institutions in ensuring that international dispute settlement rules remain fit for purpose into the future?
I think that's a great question, Esme, and I thank you. One of the key things about being at an institution is that you have a lot of substantive expertise, and you see, for example, a rule implemented in a number of different factual circumstances in a number of different ways. So you really get a broad understanding of how the rule can operate and how it should operate. And I think that that means that as an institution, for example, in the amendment context, you're able to ensure something that is workable overall. The second thing, and maybe it's the other side of the coin, is that you really don't have a particular client or a political role. Your client is the institution itself and all of the stakeholders, and that means that you have every incentive to make sure that it is a balanced and workable solution. That doesn't mean that you cannot innovate. You certainly can, but your innovation obviously must be within the realm of something that gets consensus from the majority of delegates. And I know certainly during the amendment process, we had a lot of discussions, and our mantra became, we need something that keeps the balance between investors and states. Otherwise, we will lose credibility and legitimacy. And that was a very important overriding goal, to try and keep the innovation forward and an advance in thinking, but something that could be accepted by all of the delegations. So the goal really was consensus. I think it helps to temper extremes. It helps to make sure everybody is acting from the same basis of knowledge. And the result is, it's probably no surprise that, at least in the arbitration context, we have seen a lot of institutions leading the way on a number of reforms. So think, for example, of third-party funding rules, transparency rules, diversity of arbitrators, manifest lack of merit. All of those kind of procedural innovations have by and large first been advocated by the institutions and then have become a part of the practice. So you're really in a very particular, special, in a privileged role, that you are able to help make sure that you get from point A to point B and maintain your relevance, but move the field a little bit farther ahead. So it really does have an impact.
Right, thank you, Meg. And sticking with investment, but picking up on the theme of intersections between various areas of international law, which was something also that is a thread through a lot of David's work. Philippa, your chapter is titled By Effective Means, Cross-Cutting Aspects of Fairness in International Dispute Settlements. What do effective means clauses in investment treaties reveal about fairness, both in investment treaty arbitration and for public international law more broadly?
Thank you, Esme. And I'm very honoured to have contributed to this book, to be on this panel, and to be on this panel at ASIL, which is where I met David many years ago. So my chapter draws on David's expert opinion in Chevron and Ecuador from 2010. And he addressed the meaning of Article 2.7 of the US-Ecuador BIT that reads, each party shall provide effective means of asserting claims and enforcing rights with respect to investment agreements, and investment authorizations. And his key conclusion was that the provision sets forth a positive and mandatory obligation to establish and supply measures that are not only designed to, but also adequate in practice to facilitate the investor bringing a cause of action. And I'm just going to highlight one aspect of the effective means standard in David's opinion that corresponds to a broader notion of fairness in public international law. And that's the notion of undue delay. Undue delay in domestic court proceedings may constitute a violation of the effective means standard in an investment arbitration. And in his opinion, David explored the jurisprudence of the European Court of Human Rights, the Inter-American Court, and he adopted 4 factors for determining whether an undue delay had occurred: the complexity of the litigation, the significance of the interests at stake, the behavior of both litigants, and the overall conduct of the relevant authorities. And we can compare these 4 factors with the analysis of the UN Human Rights Committee under Article 14 of the Covenant on Civil and Political Rights, and we see a high degree of correspondence. So the Human Rights Committee also sets out 4 factors for determining whether a delay is undue: the complexity of the case. This is equivalent to complexity of the litigation. The conduct of the defendant, which we can say is similar to the behavior of both litigants. The conduct of the authorities, and the level of prejudice to the defendant as a result of the delay, which relates to, but is not obviously the same as, the significance of the interests at stake in a civil proceeding. Interestingly, in practice, the Human Rights Committee has not consistently taken into account that last factor of whether the delay resulted in any prejudice to the defendant. And there are limitations as to how transferable this understanding of fairness may be between investment arbitration and human rights cases. The prejudice to a defendant is not necessarily what is at stake for an applicant in a civil proceeding. Long delays may interact with other fair trial rights, causing prejudice to the defendant's ability, for example, to mount a defense. Evidence may be lost or degraded, witnesses may forget, and certain defendants are more vulnerable to the impact of delay, such as people in pretrial detention, juvenile defendants, or defendants on death row. In the UK, the number of people in pretrial detention is at its highest level right now in 50 years, often beyond the 6-month time limit. And in the US, the average time between sentencing and execution for people on death row is 227 months. This is quite different to what a civil party faces in a delayed proceeding. But returning to the overall concept of fairness, in his expert opinion, David observed that the effective means obligation is part of a broader trend seen in other treaties supporting the rule of law and access to justice. In what would become his final address at the American Society of International Law in 2017, David said the following, which I think puts this in context. If one speaks in terms of process, then it is the institution of judging that needs to be particularly valued. In order to strengthen that institution, it is important to acknowledge that it depends on the independence and impartiality of judges, the demand that reasons be given by judges, and the obligation that the parties be treated both fairly and equally.
Thank you, Philippa. Just sticking with this theme of connection, and it's one that runs through the book in various layers, both substantively, so that the various chapters in the book engage with connections between different forms of dispute settlement, between the law and procedure applied in fairly diverse settings, and connections between recurring challenges that occur across international disputes, and that in turn brings into focus connections between the history and the past of international dispute settlement and possible futures. But a really key part of the connective thread that also runs through the book is the connection to David and to David's work. So many of the chapters in the book have been authored by David's friends and colleagues, and the volume as a whole aims to engage with David's work and to pick up and elaborate upon conversations that David started himself in his research and in his practice. So this is the theme I'd like to put to each of you in turn, and I might start with you, Meg. Really, the question I have for you is reflecting the focus of much of David's work in both academia and practice. A lot of the chapters in the book engage with international commercial and investor state arbitration. We have chapters on David's rule of X, on the controversy around the role of tribunal secretaries, and on early dismissal rules for claims manifestly lacking legal merit. And so my question is, in amongst that context, what do you think is the key lesson we can draw from David's work in relation to international commercial and investor state dispute settlement?
What I see in all of that is a real optimism about arbitration and dispute resolution if done properly. And for example, just in that rule of X, and the rule of X is basically the idea that an arbitrator should basically govern themselves according to their availability, that you shouldn't have hard and fast rules, but that it was your ethical, personal obligation to make sure if you took on a case that you had the time and bandwidth to do it properly and effectively. So I see a real stress on self-regulation, ethical conduct, high professional standards, and a real optimism for arbitration if done according to those kinds of mores. I think it's throughout David's writing. The other thing that I see that's wonderful is just a real sense of pragmatism. And finally, I'd say an intellectual curiosity, recognizing that as an arbitrator, you have to play basically a very apolitical, impartial role, yet you're probably on a tribunal that was set up to address something that by its very nature is at least a little bit and perhaps a lot political in nature as between the parties. And so David really understood that the more the arbitrators and the decision makers were impartial and level-headed about this, the more they were able to contribute to resolving something that by its very nature probably was a little bit of a rocky fact situation as between the parties. And I think that goes throughout his work, but especially the work on tribunals and courts.
Yeah. And I think that idea of context and also the role of international courts and tribunals is something that really animates a lot of David's work, as you say, but is something that our contributors also pick up on and elaborate further in their chapters. Philippa, many chapters in the book also engage with interstate adjudication. Professor Shani, for example, examines international courts in a politicised world. Judge Youssef considers the growth of regional courts and the judicial settlement of interstate disputes in Africa. And Professor Alter asks in her chapter whether we have reached the high watermark of international judicialisation. What does David's work reveal about the evolution and future of interstate adjudication?
There's so much in David's work that's of relevance for understanding today and tomorrow and beyond. And I'm just going to pick two overlapping aspects of interstate adjudication where David's work is illuminating. The first is we're seeing increased and intensified litigation on collective rights. And the most visible example of that is climate change. In September, ITLOS held advisory proceedings on the specific obligations for states regarding the pollution, protection, and preservation of the marine environment. Over 50 states and international organizations participated. 2 weeks ago, 92 states and organizations submitted written pleadings to the ICJ following the General Assembly's unanimous request for an advisory opinion on climate change, a process driven by a group of students from the Pacific Islands. A request on the climate emergency and human rights is pending before the Inter-American Court, and 100 civil society groups are working on a request to the African Court, perhaps helping to reverse the underutilization of African courts that Judge Youssef mentions in his chapter. The second aspect, which also can overlap, is that we're not just seeing litigation on collective rights, we're seeing litigation on current conflicts. The conflicts and the rampant international law violations that come with them arising from the Russian invasion of Ukraine and the Israel-Gaza conflict are being adjudicated by the ICJ in real time. And this litigation has striking features. The mass intervention of 32 states in the Ukraine-Russia Genocide Convention case, the repeated use of provisional measures, the unprecedented participation of 50 states in the Palestine advisory opinions in February, the new prominence of the Global South with contentious cases based on collective rights being brought by South Africa and Nicaragua against Israel and Germany, and with the UN Security Council being largely deadlocked on these issues, we're seeing what Professor Alta in her chapter calls, and predicts actually, having published it before these events took place, judicialization through the transfer of disputes from a political to a legal arena. The claim made in Professor Shani's chapter is more relevant than ever. He says that while it is vital to separate law and politics, there are unavoidable points of contact between the two domains. And I think David would have agreed with Professor Shani's argument that international courts should take cognizance of their political environment while also, and importantly, upholding legal norms. And this can be done through techniques such as strategic transparency, differing levels of deference, and flexible remedies. David's writings on institutional design, a political theory of international courts, the wider social functions of dispute settlement, the relationship between the multiple functions of international courts and the tasks of adjudicators, and his joint work with Esme on dissecting backlash can all help us understand the landscape of international dispute resolution. And nearly 4 decades ago, as a young attorney in San Francisco, David wrote on interim or provisional measures, noting the tension for judges between a desire to protect a party quickly from a prejudicial act and the danger of rushing to a decision that in fact prejudices the other party or the litigation itself. And he writes, 4 decades ago with such mature confidence and insight, analysing the choices of a court in balancing urgency, procedural rights, and the scope of relief. And I only wish that we could benefit from David's insights about current dilemmas in provisional measures, including requests for modified or additional measures and the potential misalignment between measures ordered and a determination on jurisdiction.
Thank you, Philippa. Another connection is a more personal connection between many of the authors and David, and we've already heard about the vastness of David's generosity as a mentor and a guide. And Hannah, you end your chapter by noting the benefits you have drawn from David's mentorship in your own career. And it's something that multiple contributors in the book note, and something from which I too have had the fortune of benefiting. And so I hoped you might therefore be able to expand on what role mentors like David play in the development of international dispute settlement and the sustenance of the scholarly and practitioner communities that constitute it.
So I first got to know David as his student at Berkeley Law in 1998, and I have fond memories of him regaling us with song around finals to help set us at ease as we were heading into our exams. That was, in my mind, just a classic example of who David was, such warmth and such generosity. And one thing that I want to comment on with regard to his generosity and how it has impacted, I believe, the community of international dispute settlement scholars and practitioners is that he manifested always inclusivity. I am a longstanding member of this society because of him. And he welcomed individuals such as myself with, different backgrounds. I don't squarely fit in international dispute settlement as a career, but he welcomed individuals such as myself with more of a human rights focus into this world and connected me with individuals and mentors who remain dear friends to this day. Relatedly, David was not territorial or fixated on boxes in various areas of international law and scholarship and practice. As was mentioned, he was more of a generalist, and he saw the interconnections And as a result, for someone with my focus, I've had the opportunity to work with some of the top international dispute settlement practitioners, such as Lucy and others, on matters impacting critical human rights situations. Further, as a professor, David saw the potential and unique contributions of each of his students and what they could bring to the field, and actively sought to facilitate so many of us being able to break in. I want to say, Joan, he was my mentor, but he was actually my sponsor. He actually opened doors actively on my behalf, which I've mentored a lot of students at this point. I've had the joy and benefit of working with hundreds and teaching hundreds over 13 years now in academia. And that takes a lot of work and energy and time, and he always had that for me and for many others. And it's something that I will always appreciate. You could tell he took personal pride in our success. He was such an inspiring role model, and it's something that I've tried to replicate in my own career as a teacher. Finally, while David was clearly a brilliant scholar, teacher, and practitioner in international dispute settlement, he was refreshingly such a great example about being non-egotistical about that fact and encouraging many of us to then join the fold. The international dispute settlement community is better for it, and he is remembered and cherished for how he brought people together with his charisma, his warmth, and his charm. He was so authentic and humane in all that he did, and I know that many in this room, like myself, miss him sorely to this day.
Thank you, Hannah. One of the striking things I think about David's work is its longevity, and often in his writing he was engaging with the role and limitations of international law for anticipating and responding to many of the pressing challenges that are likely to confront not just international lawyers but humanity at large in the coming years. And so I'd like to conclude our panel section by asking each of you to briefly comment on how adapted international dispute settlement is to addressing the challenges of tomorrow, be that environmental degradation, climate change, populism and backlashes against international law, or problems as yet unforeseen. Might start with you, Philippa.
Sure. So in her defining article, International Law, A Discipline of Crisis, Professor Hilary Charlesworth, now Judge Charlesworth, observed that international lawyers are fascinated, even obsessed by crisis. And viewing discipline through the lens of crisis encourages us to cast ourselves grandly in an heroic mode. But this focus on crisis comes at considerable cost to the discipline. She pointed out that the crisis model is technically limited, static, and narrows the agenda of international law. And David also wrote about the dangerous and ad hoc nature of legal development in response to catastrophes. So my takeaway is that we need an epoch approach to international law, a broader frame of reference that encourages us to learn lessons from the past and take a longer-term view of the future. And applying this to international dispute settlement, and in honor of David, I propose the 3 Ds. So first, diversifying international dispute settlement, and with the inclusivity that Hannah has importantly highlighted. And this is at the international bar, among parties, and on the bench of international courts and tribunals. Second, democratizing participation in dispute settlement. Many disputes are not bilateral. They involve community interests and collective rights. So we should explore the role of different models. One of them is citizens' assemblies, to give a voice to those outside of the state-centric structures of international law. And third, domesticating international justice. International courts are sites for strategic litigation, increasingly so. But what is the bigger picture? We need a playbook for the consequential action to help survivors. What happens after we get the opinion or the judgment? And that includes thoughts around domestic litigation, international organization action, sanctions, reparations, and legal and institutional reform.
Pass to you, Meg.
Thank you. I think international law actually is very good at responding, at anticipating problems, What is difficult, and this is not just an international law issue, this is many, many disciplines, is anticipating and then addressing fully. And here we have a particular dynamic, which is the key role of the state. And in many ways, certainly in the investor-state context, I think states have addressed these kinds of issues. So I look, for example, about the whole debate of police powers, and then it has now become a regulatory authority in a number of treaties. So it has eventually been dealt with. Similarly, we've seen a number of treaties try to address human rights counterclaims in the investor-state context. So it does happen, but I think one of the issues is that it happens in a very incremental fashion. And I think there's an article by Michael Reisman and Manus Arsajani, and it talks about parallel proceedings. And one of the very apt things that they point out is the problem of piecemeal treaties, treating one part of a problem or one issue at a time and resulting in fragmentation. And I think that happens in a number of disciplines. It is not a surprise. It's not just a law issue. We have these very complicated problems that are, by their nature, incremental. So we respond, we anticipate, but the solutions are the tougher part.
So as I noted in my remarks on mixed claims commissions, particularly focused on the EECC, I think that there's a lot of promise and potential with respect to current frameworks for international dispute settlement mechanisms, but there's also a lot of work to be done in adapting them for meeting the challenges in today's world and for working for peace. What I learned from David was not to shy away from recognizing the limitations that we see, but to constructively critique and engage with them in order to make international dispute settlement mechanisms more responsive and proactive for meeting today's challenges. David was clear-eyed about the limitations in our current international legal order, but never lost faith, in my experience, in the necessity of making international rule of law stronger as necessary for meeting the challenges that undeniably connect and impact all of us. And it's my hope that I can maintain some of that faith and optimism even in the face of a lot of cynicism in today's world with regard to where we're at with international rule of law.
Thank you, Hannah. And on that note of optimism and pragmatism, we have a little time now, happily, within the time we have allocated for audience questions or reflections on any of these themes, or more broadly, if you'd like, reflections on David's legacy and work in connection with the themes that the panel has been discussing. So I might open the floor to the audience now.
Hi, my name is Chuck Newcomb from the Department of Justice. Two comments. One, David was well known for international claims processes with the Iran-US Claims Tribunal and the United Nations Compensation Commission. So he had a big influence on those. But one thing that I think should be pointed out is that those in turn have had a lot of influence on domestic claims programs. Two examples are the September 11th Victims' Compensation Fund and the Foreign Claims Settlement Commission, also run by the Department of Justice. So his work internationally has also had a benefit here in the United States. And the second point that I wanted to make was that there was an article that he wrote like in the early 2000s. I think it was like a political theory of international tribunals, where he cited this synoptic chart that had a chart of the international judiciary in context. And that chart, I think, probably cut off like at the early 2000s. And I don't know if it's been updated since then, but if it has been updated, the entries that would come after whatever was left would have such have been influenced and shaped by his writing and the work. And as one of the themes of these international tribunals has been flexibility, we've come a long way since the early days of the Iran-US Claims Tribunal. And the claims commissions that have come after that, it's just been, I don't think it was imaginable at the time when he was doing his work where we are today in 2024.
Thank you. Do you want to comment, Philippa? I don't know if that the point about influence on domestic institutions intersects with your triple D.
It does. It's the domesticating of international justice, and it's just another example, and I think it's a very pertinent one. That we can. It's a sort of synergy, one hopes, in an ideal world, rather than a blockage. The relationship between international and domestic proceedings, and what my third D is aiming at is that we're putting a lot of energy into the international litigation at the moment, but we need to be looking ahead to be looking to the future, as David so often anticipated, and thinking, how does this modify what we will do at the domestic level, which is actually where the survivors and the beneficiaries are located. Just to say, I think I know that chart, and I think it hasn't been updated since the research grant that funded it ended. But yes, there should be a color coding to show the continuing influence of David, because I'm sure it would be very significant. And there's many more institutions to add to it.
Sean Murphy, professor at George Washington University Law School and a former president of the Society. I just thought I would mention one thing that hasn't come out in the course of the conversation in relation to David's connection with the Society, which is that when he was president of the Society, he is the one who established the mid-year meeting with a research forum. And his idea was, and it's consistent with the idea of mentorship that many have spoke of, that he thought it was important to have a place where particularly younger scholars could come to present papers, which isn't really what we do here at the annual meeting, but at the mid-year meeting, an opportunity for young men and women and others to come and present scholarship that might lead them along in their path. When David passed away, the Society decided to create the David D. Caron Fund, which many, including those in the room, were very generous to support, including Judge Brower, who's there in the front row. And that fund has been instrumental in doing two things. One is helping to fund the travel of young scholars, both in the United States and abroad, who otherwise could not afford to come to the research forum to present their papers. And then secondly, the Caron Fund creates a prize for the best paper presented at the research forum, which is announced at the forum, but then conveyed here at the annual meeting in this very room during the general meeting. So I think it's just a further testament to David's continuing influence and legacy for not just the current generation, but the generations to come.
Thank you, Sean. I think David's connection to the Society makes it particularly nice for us to have the opportunity to launch this book here, because this was really a society of people that meant a great deal to David, and certainly his commitment to fostering interest in the careers of up-and-coming practitioners and scholars in this field and in many others, and also communicating about the importance of international law to diverse audiences, I think is a theme as well that is picked up in some of the chapters of the book, importance of reaching new audiences with international law.
I think I might add myself to the list of those to whom David, in a sense, was a mentor. Oh, you did? Okay, you can hear me now? I've been so many years as an advocate, usually people can hear me without a microphone. But in any event, David, when he came to work for me in The Hague, was already the oldest person to come and clerk for me. An important aspect of his life was that he graduated from the United States Coast Guard Academy, got a free education, which he needed, and then spent 5 years fulfilling his duty to serve his country. From that came a lot of his interest in the environment. And I remember him saying, well, as I say, he was older because he had spent a year in a Fulbright in Wales, where they made good use of his singing ability. And he had worked a bit at a law firm in San Francisco. He was much more mature. 5 years make a difference. 5 years in the form of the military can make a lot of difference. And he was and he knew a lot about international law by that time. And we became, we sort of mentored each other through life, because it didn't take him long to get to the point where we were trying to help each other out in every way possible and make every advance we could. And sometimes he could help me, and sometimes I could help. I could help him, and we tried 3 times to get him to The Hague. Third time we were successful. Unfortunately, then he died not too long after that. But this was a mutual mentorship, let's put it that way. And I'll always be very grateful for David and his life and our time together. We were inseparable. Thank you.
Thank you. I think that's probably a nice note to end our panel discussion on. And the formal vote of thanks will be delivered in a moment, but on behalf of the editorial team, I'd really like to thank our panelists and numerous contributors to the book for your invaluable contributions, not just to this discussion, but to the book as a whole. And our thanks as well to David's family and David's wife, Susan in particular, for entrusting us with this project, which it has been a real honour to work on, and a really nice journey to engage more systematically with David's work and to remember his many contributions to the field at both a substantive level, but as you've heard as well, a very personal level. So as we say in the introduction, a final person really to thank, who we very much wish was here to receive the thanks, is David himself. And we, I think, collectively on behalf of the panel and the editors and numerous people in the room have benefited so much from everything that David gave us, and will be grateful for that for our entire careers and lives. So given the time, I would now like to hand over to Susan to close our session.
Um, 6 years ago, David's death was a surprise, very unexpected, and kind of the grief and the impact were literally felt around the world. While I lost my partner and love of my life, everyone who contributed to By Peaceful Means experienced a loss. Esme, of all things, lost her PhD advisor right in the middle of things. Kian, his mentor and one of his best friends. Simi, a former professor. Joan, a trusted colleague. Charlie, as he just said, went from a protege to a colleague. And you, the essay authors, all of you lost someone, whether it was a fellow international law professor, a fellow arbitrator, a fellow judge, a mentor, a professor. And everyone, as has been said already, lost a very generous man with a big laugh who loved to engage with international law. Okay, I'll breathe. And since it has been 6 years since David's passing, I hope all of the editors and authors experienced warm memories of David as they worked on their essays. And I thank all of you for your contributions. And I know David thanks you as well for furthering peaceful means on resolving conflicts, international law, and that value meant so much to him. And on a more personal note, I have to thank Kian, who not only saw me through the darkest days 6 years ago, but really did envision this collection of essays. So thank you all very, very much, and enjoy the book and his memory, and thank you again.